On December 5th, the justices heard Lorie Smith's 303 creative case involving her web design business and her objection to Colorado's public accommodations law, because she says it forces her to create custom websites that violates her First Amendment rights, messages that she disagrees with. For example, she wants to enter the wedding website design business, but if she tries to work under Colorado's current law, she would also have to design websites for same-sex couples, which runs against her faith and the messages she wishes to put out there. I'm joined by Ms. Smith and her attorney, Kristen Waggoner, with Alliance Defending Freedom. I appreciate you both for taking time to join me and all my little technology issues this morning, so appreciate your time. But Ms. Smith, I wanted to speak with you first. I wanted to ask you, I know this has been a 6-year long court battle for you, challenging this law. And I wanted to ask you, now that the case was heard earlier this month by the justices, how that feels, knowing that the oral argument part is over, or do you feel any relief, or do you still feel like a weight on your shoulders, given that it's probably going to be months before we actually get a ruling?
Well, this has certainly been a long journey. It's been over 6 years now, and I've always remained hopeful. And as we walked out of the court after oral arguments, I remain hopeful. I am grateful for this opportunity, and I'm looking forward to the court protecting everyone's right to speak freely, not just mine, but the LGBT web designer who shouldn't be forced to communicate messages that oppose same sex marriage. Free speech is for each and every one of us, and it's worthy of protecting.
And I know I was in the courtroom during arguments, and there were some wild examples that came up. Some of them ranged from photographing a cisgender couple who have some sort of message on their website that you might disagree with. There was one example Justice Jackson kept coming back to, which was about a photographer who only might want to photograph white children with Santa. The hypotheticals were kind of all over the place. But I thought I'd ask you, Ms. Waggoner, basically, what did you make of some of the line of questioning that the justices threw your way during oral argument?
I think the justices are naturally testing the limits of a principle that the court has followed for over 100 years, and I believe will be upheld in this instance, and that is that free speech is for everyone. Public accommodation laws and free speech rights have peacefully coexisted for many, many decades. We've been able to protect speech, and it's illegal to decline to serve someone because of who they are. The justices, many of them on the court, rightly pointed out during oral argument that Lorie bases her decisions on what the message is that she's being asked to create and not who the person is. And we heard some of the justices echo that as well. She serves everyone, including those who identify as LGBT. But again, she's looking at what is the message you're asking me to create in this custom speech that you want me to express.
Yeah, and I remember, I think it was maybe possibly Justice Gorsuch, he basically said, so is this about what, but not whom, right? Like not discriminating against a certain client, but the actual, what is the message? So I guess I'll ask you, if the justices were to rule in your favor, what type of implications would it have? I guess like for Ms. Smith first, like personally, what would it have, and how would it impact your life?
Well, first of all, in terms of how the law would impact Ms. Smith as well as many others, it would mean that they don't face fines and re-education, and in other states, even jail time for declining to create custom messages that violate their beliefs. But it also means that all Americans maintain their right to be able to speak without facing government punishment. And that includes, in many jurisdictions, they have political ideology, for example, as a protected class. So Colorado's theory is that Democrats should have to write press releases and speeches for Republicans. And that's not an America any of us want to live in. And it's not what the First Amendment allows the government to do.
Yeah, I remember when we spoke previously, when we're talking about like the personal ramifications. I know there's been other small businesses. I think there was an Oregon couple who were fined $135,000, had to shut down their business because of the Oregon state law. But in the legal sense, what you were getting at too, I think you've mentioned previously to me about the number of states that have these types of laws, and even like how they can get towards, political ideology and that sort of thing. So I know it could have widespread effect. And it seems like it looks to me, sitting in the courtroom, like the justices are looking to draw a clearer line than they did a few years back when Jack Phillips brought his case before the Supreme Court dealing with the same type of state law, trying to force him to make custom wedding cakes for same-sex couples in violation of his First Amendment rights. So I really appreciate y'all's time. I know, given how the court works, this is one of its major cases, and that usually means we have to wait long to hear what the justices have to say. Do you expect a ruling to come in June?
We expect the ruling to come at least by June. It perhaps could come earlier, and we're hopeful. Colorado has relentlessly pursued Lorie and others who share her beliefs, and we're looking forward to free speech being vindicated for everyone.
Well, thank you guys for taking the time to join me. I really appreciate it. I know you've had a lot of interviews since December 5th, and probably even before then when the arguments took place. So I appreciate your time.
Thanks for having us.